Yes, Mr. Francis.
May it please your ladyship. If I may start just with some housekeeping.
Yes, certainly.
Sure
Before you launch into your housekeeping,
yes.
if I can just say that we've had an opportunity of doing a considerable amount of pre-reading, not just of the judgments and skeleton arguments, but dipping into the materials as well. So both be assured we've taken that opportunity.
I'm very grateful. Can I just check you have an agreed additional bundle?
Yes.
And an unagreed additional bundle?
Yes.
Before you go any further, I appear not to have a whole series of bundles, which were in my room and are not here. I think...
Excuse me. Excuse us a moment.
So I don't have those, although I know that I do have them. Please would you go back to my room, which is... I don't know. Yeah, find my clerk. But I don't have one at the moment. So Julie, who is in the first clerk's room as you go back down the corridor, and ask her to find the extra bundles, which are still, I think, probably on the shelves at the end of my desk.
So
Thank you very much.
bundles.
Yes, extra bundles, which should be there. Thank you. I'm sorry.
Thank you very much.
That's a very bad start.
I do have some spare bundles here just in case.
Oh, okay. So let's stop then. So all I have is a core and a supplemental, and nothing else. And have handed up here joint supplemental authorities.
So I have the agreed bundle and the unagreed bundle.
Yes, but then do you have an authoritative bundle as well?
I don't have an authoritative bundle.
Okay. May we rise and may I just go
Yes,
and
let's.
fetch
I
them?
think that's...
I'm so sorry, but because I'm between clerks, I think it would be better if I went and found them. Excuse me.
Sorry, everybody.
She may not have your 2 letters, which are in that pack there.
Yeah.
Thank you.
I think we can rewind now, Ms. Francis.
Yes.
Yes.
So the agreed bundle of additional documents, if I can just very quickly these, contains documents which were before the courts below.
Yes.
Mainly plans, which should have been included in the appeal bundle, but weren't, I'm afraid. And there's also an aerial photograph fortuitously taken in 1969.
Yes.
Which is behind tab 6. I won't.
Yes.
I won't take any time taking you through those documents, assuming that you have already had a chance
Yes.
to see them. The first item of business then this morning is our application to produce fresh material.
Now, before you launch, we've obviously read your application,
Yeah.
and we've seen what the material is.
Yeah.
And I think this arises out of paragraph 43 of the respondent's skeleton argument. Our preliminary view is that we don't think paragraph 43, with respect to the respondent, is helpful. It's the views of the respondent don't inform our decisions, and our feeling at the moment, therefore, is that we won't be taking into account the respondent's view, and therefore it's not necessary for us to consider the documents that you've produced in response to the expression of that view.
Will you nevertheless hear me as to why I say the court should?
Well, only briefly, because whilst Loudon Marshall is no longer a straitjacket, all of these were available.
Yes, and we accept that.
And so we are, time constraints, apart from the hours.
Yeah.
But we'll hear brief submissions because we have, of course, read the application.
Yeah. The issue before the court on the appeal is one as to the proper construction of the exclusion clause in the 1974 Headleys. And that, of course, is a question of law on which this court may substitute its own view for those of the judges below as to the proper interpretation of the clause, and the approach of the appeal court to questions of construction, of course, is different from that which it is in relation to questions of primary fact or relative judgment as found by the trial judge. So far as questions of construction are concerned, of course the court has to determine questions of construction in the relevant factual matrix or context in which the instrument in question is presented into. It's my submission that for the purposes of this court having the relevant context before it, an appeal court should be less carey about the admission of fresh material.
You didn't find it necessary for the first appeal.
That's correct, and as I've explained in my skeleton argument, at the appeal below, we were proceeding on the basis that it was a reasonable inference to draw from the material which was before the court that there were such utilities under Sheldrake Place. And the point, as it has now been taken in the respondent's skeleton argument.
Well, he's shaking his head. I've already said, I hope, as a hint
Yes.
in your favour,
Yes.
that I really don't think that any of us find an expression of the respondent's view of any help to us at all.
Yes.
If it assists my learned friend, there's nothing in paragraph 43 which changes our position from the position it was in front of the appeal judge. We do not now advance a positive case that there are no services under Sheldrake Place. We couldn't because there was no evidence. Our point was simply that it wasn't obvious. It's to meet the construction point that it is absurd that the judge because it's absolutely necessary. The parties would have deemed it necessary to have services under Sheldrake Place East. And we say there's no evidence that was the case.
Well,
Second, it's not obvious that you need one because of the highway, but there's no way. We don't put forward a positive case that there are. Or are not.
So we have today the position where I will nevertheless be inviting the court to infer that there were or may have been utilities apparatus under Sheldrake Place East based upon the material before the courts below. My learned friend will be inviting you to infer the opposite.
Well, I don't think he's... I thought he just said he wasn't in a position to say one way or the other.
Well, his position, I think, is that our assertion that there is, or our invitation to the court to infer that there is mere speculation, which he will, he has said that the court shouldn't make any such inference, amongst other reasons, because there was no grant of express utility rights under the original 1938 head lease of Duchess of Bedford House. So we are, I think, probably nevertheless going to be inviting the appeal court to draw such conclusions as are available from the material which was before the courts below. And the difficulty is that there is additional material which has now been obtained, which casts further light, and we say casts further very clear light on the position as to the existence of utilities infrastructure under Sheldrake Place East at the time of the 1974 head lease. Now,
but does it do that? Do we have to make further inferences and surmises in order to get ourselves back to 1974?
You do have to make, I mean, for instance, the Thames water plans show the mains water pipe and connections running from the mains water pipe under Sheldrake Place East to a meter in the front of Duchess of Bedford House. They don't show any private supply pipe running from that meter to Duchess of Bedford House. But we would say it's a fairly obvious inference to make that there is such a connecting supply pipe. Otherwise, why would there be a meter in that position? You can see similarly there are meters positioned in front of the other residential blocks similarly served by the water mains. So it's a fairly obvious inference, we say, that the court can make. So all I'm really inviting the court to do is to put itself in a better position for the purposes of determining the proper construction of the 1974 exclusion clause. And for those purposes, I do accept that I couldn't come before this court with witness evidence saying what, in the opinion of Mr. X, Y, or Z, was a position at any time. We have limited the material which we're putting before the court now to publicly available records, which the court can make of what they will, but the court will be in a better position to determine the proper construction of the exclusion clause in its proper context with the benefit of that material.
Thank you. Yes, Mr. Holland.
One of the insidious things about this application is it's made so hideously late that it's being heard by the same tribunal who will hear the appeal. Thereby, even if you dismiss the application, you've actually seen the material which was not before the court. And that is, I say, insidious.
Well, it's pretty routine. It may be insidious, but it's pretty routine.
Well, routine doesn't mean it's praiseworthy or doesn't mean it should be shrugged off.
No, but it does mean that the court is well accustomed to having to put matters out of its mind after applications such as this, if they dismiss the application.
Well, that's the first point. Secondly, it somewhat undermines the grounds to saying this is worthy of a second appeal. It's said to Lord Justice Nugee, who only just about granted it, that, well, this is it's a point of public importance because these clauses need to be construed. There's lots of these clauses and they need to be construed consistently. It's now said, if you want to construe this particular clause, you've got to look more into granular detail of the facts of this case. So we would submit that had this application been before Lord Justice Nugee when he made his decision as to whether to grant a second appeal, he would have refused it because there's no point of general public importance. It's all to do with the facts of the case. Thirdly, I don't accept, and the point I made, that our paragraph 43 either changes our position before the appeal judge or gives any indication that we are advancing any new or positive case. This matter didn't arise before the trial judge because the point wasn't taken until oral closing reply. It featured in front of the appeal judge, and the point I made was that there's no evidence. If it is said, the point is, it's absurd, it is said, to construe the clause the way the judge did because it will automatically prevent any services running, private services running under Sheldrake Place East. And my response was, one, there's no evidence, you didn't call any evidence there were any in 1974 when the lease was granted. Secondly, it's not obvious that you need it because there is a frontage to the highway, and we suspect that's where, it's our view, that's where the services run. That's the height of the case, that's what I said to the judge, and that's what we've repeated in paragraph 43. So there's no, the excuse advanced as to why this application is made very late in the day is that we've changed our position and we're advancing a positive case. I say no reasonable reading of paragraph 43, particularly in the context of paragraph 42, and what I said before the judge, which my learned friend and his solicitor and his clients have heard, could possibly run an excuse for what the application is. Thirdly, or fourthly, if you look at my learned friend's supplemental skeleton, he specifically replies to these paragraphs. If you look, it's...
Well, I don't think
That's right, but he doesn't take this point. If you look at the section, it says assertions of fact made by the respondents, and he deals with this section, paragraphs 42 to 45, and he does not make the point that is now made in his further skeleton and by his solicitor in his witness statement that somehow we're advancing a new and positive case. That's because he didn't understand it at that stage, and he did.
Well, I don't think we need to be offensive.
Well, I'm not being offensive. I'm sorry, I'm not trying to be offensive, but it is now advanced that we're making a positive. It's not no reasonable reading of that. My learned friend accepts that the Latin martial principles simply aren't met here. This could have been, this evidence, if it had been considered, could have been got for trial. We submit that it wouldn't have crucial significance, although it proves that there are some public utility services that run down Sheldrake Place East. There's no evidence that there were private.
Well, we're not going to get into the arguing about what the evidence is or isn't. We're deciding whether or not we're going to admit it.
Yes, it's well. If one applies the test,
I think it's conceded that the Latin martial principles are not.
It's very late. If they had been disclosed at trial in the proper, then the trial we would have had an opportunity to test them. For example, my learned friend quite candidly says, well, you have to infer, if you get this in, you have to infer that the situation was the same in 1974. You have to infer that there are private. For example, my learned friend gave the point about the meter, the water meter. Now, these plans are notoriously inaccurate. And indeed, all I'm trying to say is that there may be private rights, but the meter may be on the boundary to Duchess of Bedford House, so you've no reason for that. So we would have had an opportunity. The trial would have been different. Let me make it that point. And as I've said, it substantially undermines the reasons for saying this is a second appeal. So we would say you should reject it and ignore the evidence.
Thank you. And your reply?
Just to say, I don't accept that the sure I would have taken any different course whatsoever. My learned friend is overblowing that point in my submission.
We'll rise for a moment. Mr. Holland, we're not going to admit the unagreed documents. We'll give our reasons in our judgments. Now, I should say, because there's the issue of the respondent's notice, can I just say, so that we don't lose any more time, that we are going to hear submissions about that de bene essay, so that we hear those arguments, but we absolutely are not saying that we've made any final decision about what place they will have.
Yeah. Just on that point, just in terms of my submissions,
yes,
what I was proposing was to address you on the questions of construction as to the 1974
yes,
head lease.
yes,
There are two questions of construction in my appellant's notice, and there was one question of construction raised in the respondent's
yes.
notice. So I was proposing to address you on those three issues of construction.
I'm sure that's a sensible thing. And let's deal with all the construction together and then reply together. I'm not a great fan of going backwards and forwards.
Yeah, but what I won't do in my opening is deal with the other points raised on the respondent's notice, which it seems to me is for my learner friend to develop and for me to respond in due course. If that's acceptable.
Well, unless it actually is more simple, and you agree between you that it's more practical to simply to weave it into your overall submissions. I don't have a strong view. It's a matter for both of you to decide how best to work that.
From my viewpoint, it would be easy for me to hear what my learner friend says.
I agree. I don't disagree with that.
Well, we're happy to deal with it however you two wish to deal with it. Yes.
Right. So, as I say, there are three issues of construction on the 1974 head lease. The first is as to the construction of the clause as a whole. Do the words except those now subsisting, except from the exclusion as a whole, subsisting rights, or are subsisting rights caught by the exclusion where they're ones which might restrict or prejudicially affect future rebuilding, etc.
And so the effect of that is, does that clause, which is in the middle, stay in the middle or go to the end?
Yeah.
In a nutshell. Second, and this is the respondent's notice point, what is the meaning of the words those now subsisting? Does it apply to any existing rights which were at law or pertinent to Duchess of Bedford House, which is the appellant's submission, or does it have some more limited meaning, as respondents suggest, he says, limited to rights which were granted in favour of Duchess of Bedford House by the 1938 at least. And the third question of construction is as to the second limb of the exclusion, if that's how you part it, the words which might restrict or prejudicially affect. Does the word might connote a requirement that is, in my submission, has to be a real prospect, or is it enough that it is simply a possibility? And on that question, the judges at first instance and on the first appeal differed, and I invite your ladyships and your lordship to prefer the approach of the first instance judge. There is then one further matter on the appellant's notice for determination, which is as to the application of that second limb, whether the appeal judge was right to overturn the first instance judge's application of that second limb. I don't think it's going to be necessary to refer your ladyships and your lordship back to the authorities as to the proper approach to construction. I obviously invite your lordships to consider and apply the words of Lord Hodge in Wood and Capital Services, paragraphs 9 through to 13. I'm happy to take you to those if necessary, but
in your own course, exactly. Take us if you wish us to refresh our memories, or otherwise we'll simply make a note and rely on our own memories.
It's in the authorities bundle, tab 28, page 369.
Just remind those putting the bundles together the reasons that the limit is 350 pages is because they explode otherwise.
I find they explode whatever the number of documents. So paragraph 10 sets out well-established task of the court to ascertain the objective meaning of the language. Paragraph 12 refers to the unitary exercise, which involves an iterative process by which each suggested interpretation is checked against the provisions of the contract and its commercial consequences are investigated. And for those purposes, it doesn't matter whether you first look at the language of the clause or whether you look at the commercial context in which it is entered into. And then paragraph 13, if I could just invite you to remind yourself of paragraph 13, which is the In this case, there is an additional consideration to take into account in the process of the application of this exclusion clause. Just to go back a stage, on the grant of the 1974 head lease, there would have been demised with the land itself those rights which are expressly granted by the actual words of the 1974 head lease, which in this case the only expressly referred to right which is granted with the demise is a right of way over Sheldrake Place East. But in addition, there would have been demised with the land under the 1974 head lease all existing legal rights which were pertinent to Duchess of Bedford House, which were enjoyed as legal easements by the freehold owners of Duchess of Bedford House. Those rights, those existing rights, would have passed on the grant of a derivative interest, just as they would have passed on a conveyance of the freehold, automatically under the general law. But in any event, under section 62 of the Law of Property Act 1925. In addition, however, section 62 operates in one further respect in converting into legal rights or easements liberties, privileges or advantages which were enjoyed with the land, the subject of the conveyance, at the time of the conveyance. That second way in which section 62 operates, to convert what was enjoyed without any actual legal right, but as a matter of settled practice, with or without the permission of the servant owner, to convert those into rights at law, is the second way in which section 62 operates. And in Wright and McAdam, in 1948, this is in the authorities bundle at tab 13. This case concerned a residential flat which had been let to a tenant by her landlord under a weekly tenancy, and while it was so let, the landlord had allowed the tenant to use a coal shed in the garden for storing her coal. Subsequently, the landlord grants the tenant a new 6-year tenancy of the flat without any express grant of a right to use the coal shed. The tenant nevertheless continues to use the coal shed until the landlord then asked her to pay for it, the privilege, at which point the parties fall out, and we end up in the Court of Appeal, where it was held that privilege, which was enjoyed by the tenant with the permission of the landlord, was converted on the grant of the new 6-year tenancy into a right legally appurtenant to the flat. Page 748 of the authority, Lord Justice Jenkins explains the two ways in which Section 62 operates, which I've already described to you at the passage beginning the predecessor of Section 62. And if I could just invite you to read from there down to the sentence beginning legal authority. Now, turning to Section 62 itself, which is behind tab 2 of the authorities bundle. Sorry, I beg pardon, tab 3. Section 62.2 is the relevant provision which works this statutory magic. But it is subject to Section 62.4, which says the section applies only if and insofar as a contrary intention is not expressed in the conveyance and has effect subject to the terms of the conveyance and to the provisions therein contained. So the parties are free by their conveyance to exclude in whole or in part the operation of this section, whether to transmit existing rights appurtenant to the land or to convert into rights user which was previously enjoyed as a matter of settled practice. And it's accepted that the parties are able, by the terms of the conveyance, to exclude the transmission of rights, whether by Section 62 or by operation of the general law.
But presumably you'd also draw attention to the breadth of Section 62, subsection 2, which refers to liberties, privileges, easements, rights and advantages.
Yes. In the context of Section 62.4 and the exclusion of the operation of the section, it is well established that clear words are required to disapply the operation of the section. The intention of the parties must be clearly expressed, and some of the authorities invite the court to adopt a process where you write in, notionally, into the conveyance the rights which would pass under Section 62, because Section 62 treats those rights as if they were expressly set out in the conveyance. So notionally write them in, and then consider the terms of any provision of the conveyance which purports to exclude rights and see whether the language of that provision clearly expresses an intention to exclude the right which has been written in, notionally. I've referred in my skeleton, if I can take you quickly, to Gale on easements behind tab 30. Paragraphs 350.
Please could you, not now obviously, but I expect it's at the front perhaps of the file, to tell me what edition this is of Gale on easements.
This is the 21st edition.
Thank you. We're at paragraph 350.
350. If I could invite you to read 350 and 351, please.
Thank you.
The most recent Court of Appeal decision which deals with this is Wood and Waddington, the decision of Lord Justice Lewison, which is at tab 26. The facts of this case are fairly complicated, but they can be boiled down to this. This was a case involving the division and sale of a farm by two separate conveyances. The first conveyance to the appellant's predecessor in title, the second conveyance to the respondents. The conveyance to the appellant's predecessor in title had included various express grants of rights of way over what was then the retained land of the vendor. After that retained land was transferred to the respondents, the appellants then claimed additional rights of way over certain bridle ways on the respondent's land, which the appellants contended were granted by operation of section 62. They lost at first instance in that argument, but succeeded on appeal. Page 302, page 197 of the report, paragraph 6 of the holding, summarises the conclusion of the court on the question whether section 62(4) disapplied the operation 2, and that is dealt with in more detail at paragraphs 60 to 62, about 60 to 66 of the judgment of Lord Justice Lewison. If I can invite you to read those paragraphs, please.
60 to
66.
Thank you.
And in my submission, the requirement for clear words in a clause of a conveyance for the purposes of restricting the transmission or creation of rights under section 62(2) applies and must apply equally when you're considering the effect of that clause as it purports to prevent the transmission of rights under the general law. There's no reason why you would have a different approach to the construction of the conveyance, simply because in one case you're considering it in the context of section 62(4), and in another sense you're considering it under the general law. For the purpose of consistency, the same approach must be adopted. But in any event, it is clear in this case that if the rights were not transmitted under the general law, they would be transmitted under section 62, and so we're back to the same point. Do the words of the clause purporting to exclude the operation of 62 clearly indicate an intention that the right in question, notionally written into the conveyance, should be excluded. So with that preface, I now turn to the points of construction. And the first point, the overall construction of the clause. Now, I don't know how many times you've had the opportunity to read and reread this particular exclusion clause.
Plenty.
But I hope you won't find my characterisation of it as puzzling, out of place. It's not an easy clause to understand. And you can read and reread it and parse it in different ways. It never feels quite right. When I first read it, I read it for what it's worth, so that one reads through it to the word except, and then everything which follows the word except are the relevant words of exception. So there is excepted from the exclusion 1, those now subsisting, and 2, those which might restrict or prejudicially affect the future rebuilding of any adjoining land, etc. That initial reading is one which plainly doesn't work, because you wouldn't be accepting from the exclusion rights which operated to restrict the development. My learned friend would say quite the opposite. Those are the very rights you want to exclude from transmission. So that's obviously not a correct parsing of the clause. And it's at that point in my submission where it is legitimate and the reasonable person in the position of the parties to the 1974 head lease would be entitled and would have available to them the terms of the 1969 head lease, where we have a similar exclusion clause. And if I could invite you to turn to paragraph 26 of my skeleton argument. In paragraphs 26 and 27, I have, by underlining, identified the words which have been added to a standard boilerplate clause in each of these head leases. So one can see in the 1969 head lease, the words of exception to the exclusion are added at the outset of the clause, as I've underlined them. Whereas in the 1974 head lease, the words of exception, just 4 words, except those now subsisting, have been added in the midst of the clause. And as my Lady Justice Asplin rightly noted a moment ago, it is my submission that although those words of exception have been inserted in the midst of the clause, they should be read in the same way as if they appeared at the beginning of the clause or at the end of the clause. In other words, they are not words which simply apply by way of exception to any sublim which immediately precedes it, and not to any sublim which follows, but rather apply to the clause as a whole.
Could I take you back to paragraphs 26 and 27 of your skeleton and the comparison, helpful comparison that you've made between the 1969 clause and the 1974 clause? And you say the reasonable reader in 1974 would have the 1969 version in mind or available to them. Yes. But which way does it work, in the sense that you have that available to you, and you see that people, no doubt, who were very well advised and draftsmen who were very skilled and professional, came up with something different. So does not the difference between the 1969 and the 1974 clauses militate against a reading of the 74 version as if the phrase was at the beginning or the end? Because it's different.
Well, this is obviously my learned friend's point.
Yeah. But I just want to get to the bottom of what you say about what we can take from the 1969 version, and how that can be used in your argument.
what I say when takes from the 1969 version is a well-drafted clause, which one can read and immediately see its meaning. In comparison, the 1974 clause it is not well drafted, and its meaning is puzzling, as I've said. And you are left, when you compare the two, with the sense that the 1974 clause is unclear and ambiguous in its meaning. As the judges below held, the way you should parse this clause, and this is, it may be helpful to turn to Mr. Justice Johnson's judgment on this, which is behind tab 11. Paragraph 85. This is the way, in effect, His Honour Judge Gerald parsed the clause, and which Mr. Justice Adam Johnson agreed. So effectively you break the clause into two sublimbs. And you apply the exception at the end of the first sublimb, where physically it appears in the clause. And what I say about that is, well, that's all very well, but you're jumping the gun there. Remove the word except those now subsisting entirely from the clause as a starter, and that's actually your boilerplate clause, to which the words of exception have been added in both the 1969 head lease and the 1974 head lease. So, first of all, look at the clause with the words of exception entirely removed. And in doing so, the way in which it is parsed, breaking up into two sublimbs, is not grammatically elegant, but it does, I accept, explain how the connected word or fits into the clause as a whole. But then notionally add back in the words of exception. But in doing so, don't assume that they should simply be applied to the first sublimb. Keep them separate. Assume that the draftsman has just added them in the midst of the clause at that point. It doesn't follow that it was intended that they should apply just to the first limb of the exclusion. And you can't conclude that that was what the draftsman necessarily intended, because the way in which they are inserted in the midst, as I say, leaves the clause as a whole as one which you stumble through, and it doesn't grammatically feel right or make sense. My submission is that you are left ultimately on a pure textual analysis of this clause with uncertainty and an uneasy feeling that this doesn't quite make sense. And it's it's not clear what was intended, whether it was intended to introduce those words of exception as applying to the clause as a whole, or only to the first sublim of the clause as it is parsed by the judges below. And it's at that point that one then moves from textual analysis to contextual analysis. So, on the contextual analysis, which is an invitation to the court to consider the effect, the commercial background, the purpose and effect of this clause, I say, first of all, if the words of exception apply only to the first lib, they effectively give with one hand and take away with the other. I think a phrase which Mr. Justice Adam Johnson used in his judgment. In this sense, you accept the exclusion under the first lib, subsisting rights. But then you say, but they will be excluded if they're ones which might restrict or prejudicially affect future developments, etc. Now, unless you apply some restrictive interpretation to that second sublet, you can see pretty quickly that the exception in the first sublet would be rendered nugatory by the second sublet, because any right over land is one which, in some sense, will restrict the use which is made of his or her land by the servient owner, by definition. And if it restricts the user which the servient owner can make of his or her land to some degree, it is said, and it is said by the respondent in this case, it similarly might restrict alterations or development of the servient land. It's very difficult to think of a right, a subsisting right, which may pass as an exception under the first lib, which, on a wide interpretation of the second limb, would not then be caught by the second limb and so excluded in any event. So what was the point of introducing the exception in the first place? That can't have been what was intended. It can't have been intended that you would give with one hand and take away with the other. Now, under the 1969 headings, if I can take you to that, please, in the core bundle, behind tab 7. 1998. This was, of course, the grant of the head lease of the whole of Sheldrake Place, the garages, garden in the centre, and the 2 blocks of Campden Hill Gate, to the defendant's predecessor in title. The Phillimore estate, as freehold owners of both Sheldrake Place and the rest of the land is subject to this demise, and also all the adjoining land and buildings, including Duchess of Bedford House. In granting this lease, reserved for themselves the various rights which are set out at page 98, following the words "except" and "always reserved." And the first such reservation was of what I describe as utilities easements, the free running of water and soil and gas and electricity coming from any other buildings or land upon or forming part of the Phillimore Kensington estate aforesaid, in and through the sewers, drains, pipes and cables, or connections with sewers and drains, pipes and cables made or to be made upon or under the demised premises or any adjoining roadway, and so that the lessors and the owners and occupiers for the time being of any such buildings or land as aforesaid shall at all times hereafter have free access to and free use and enjoyment of the said sewers, drains, pipes and cables and connections for all ordinary or building or other purposes connected with any part or parts of the Phillimore Kensington estate aforesaid, or any houses or other buildings now standing or hereafter to be erected thereon, without making any payment to the lessees. And then, in addition, by way of further reservation, in terms of those utility easements, further down the page, beginning except and reserved, there is reserved to the freehold owner, except and reserved unto the lessors and their agents, workmen and others, full power and after reasonable notice to enter and construct any sewer or drain for the purposes of carrying water or sewage from any such buildings or land as aforesaid, through and under the demised premises or any part thereof, and the power of entry for the purposes of, from time to time, repairing or replacing any such sewer or drain, or of altering, enlarging or removing the same, the lessors and their agents or workmen doing as little damage and inconvenience as possible to the demised premises, and making good all damage done thereto. So there is reserved to the lessors these utility easements over such utilities apparatus as there may be, or may in the future be, under the demised premises. Now, whatever the extent of such utility apparatus may or may not have been, in my submission, it is obvious that the head lessee of Duchess of Bedford House would expect to take, with the demise of Duchess of Bedford House, the benefit of such rights. Not necessary for those purposes to determine or make any findings as to the extent of such existing infrastructure. That there is material from which is before the court below, from which it is from which one can see that there was, for instance, an electricity transformer station in situ in 1974. You can see that on the plan to the 1973 planning application plan, which is in the supplemental bundle.
Supplemental bundle or a further supplemental?
No, it's actually in the supplemental bundle.
Okay.
This particular plan, page 23 behind tab 4. We don't have a better copy than this, so the writing is actually not possible to make out. But on the right-hand side, halfway up, on the right-hand side we have Sheldrake Place East, and halfway up we have an entrance from Sheldrake Place East leading to a rectangular building, which is the transformer station. I agree.
Thank you.
And the date of this plan again?
This is 1973, October 1973.
Thank you.
And actually that transformer station looks as though it has been in situ since 1931, because there's a lease of the transformer station granted in 1931, which is referred to in the 1969 head lease, in the core bundle, tab 7, schedule 2, which is at page 112.
Still in the supplementary.
No.
No, this is the core bundle.
Oh, sorry, we're back to the head list.
I'm so sorry, I'm jumping around.
Sorry, I'm being blind. I can't find on page 112 the reference that you're looking for.
So you see the second schedule. And there's
Yeah.
a list of
Dates of leases 1959, 1931 at the bottom, transformer station. Thank you.
So, in relation to electricity infrastructure, you certainly know that there was a transformer station in Sheldrake Place. Now, in relation to the utility easements which are reserved by the 1969 head lease, it's clear on the construction of the exclusion clause which the respondents contend for, that those such rights, although subsisting rights, reserved for the benefit of Duchess of Bedford House and other land of the trustees of the Fenmore estate by the 1969 head lease, would be caught by the exclusion clause, notwithstanding that they were subsisting rights, if they are ones which fall within the second limb of the exclusion clause, as ones which might restrict or prejudicially affect future development, etc. We say that cannot sensibly have been what was intended. And that is a reason why, when you are construing the terms of the exclusion clause, you should construe it so that the exception to the exclusion applies to the clause as a whole. When one looks at the judgments below, in the first instance, His Honour Judge Gerald dealt with this very briefly at paragraph 86 of his judgment, which is at tab 14. And whilst acknowledging the wording of the clause was garbled, he considered that the ordinary and natural reading of the clause was that which we now seek to appeal. Mr. Justice Adam Johnson conducted a more wide-ranging analysis in which he found similarly that the clause was difficult to make sense of. So tab 11, page 80, so paragraph 83, he noted the language of the provision was rather inelegantly expressed, and then having summarised the party's position and the judge's position below, he then at paragraphs 95 through to 104 set out his own conclusions in relation to the construction of the clause as a whole. And in particular, paragraphs 101 to 104. If I could just invite you to read 101 to 104, if you haven't done so.
We have, but we'll read it in the context of your submissions.
So what the judge effectively did was apply his own notions of what made commercial sense to, in an iterative process, to reach the conclusions he did on construction. He had resort to commercial common sense, which in my submission he was correct to do so. But where he went wrong, in my submission, in applying his own theory as to how the competing interests of the Finnemore estate and the head lessee were to be balanced or compromised was to be struck. In my submission, that was pure speculation on the part of the judge. And in so speculating, in my submission, he didn't give proper or adequate consideration to the effect of the rendering nugatory the exception of subsisting rights. That's the point of giving it with one hand and taking away with the other, and in preventing the transmission of the utilities easements. As this is a question of construction, this court, as I said in my opening, is in the same position as the appeal court and may substitute its own conclusion as to the proper construction of this clause, even if Mr. Justice Johnson's decision is one which he could reasonably have come to. We can all reasonably come to conclusions on questions of construction. That doesn't bind this court in the sense this court can substitute your lordship and ladyship's own conclusions as to the construction.
Mr. Ronson, I have slight trouble with the idea that what he did was mere speculation, because one could say that anything that any judge does about looking at a clause in the light of its context and seeking to apply commercial common sense is that judge's understanding of commercial common sense in the light of the clause and its relevant background. And so rather than saying he's speculating, what you're really saying is that his construction doesn't make commercial sense. Is that fair?
It is, yes. Yes, thank you. But this then takes me back to where I started with the requirement for clear words.
Just forgive me
Yes.
before you go to that. I understand that you say it doesn't make sense because it doesn't deal with the utilities the way you were saying it should. Is that the reason why it doesn't make sense?
That's one reason, but more widely, as I said it, unless you adopted a more restrictive interpretation of the second limb, which I'll come on to in a moment, because the second limb will apply to any right you can think of if you adopt a liberal interpretation of the second limb. The exception, if it applies only to the first limb, is simply rendered nugatory.
I see.
So when one notionally writes into the 1974 head lease, all the rights which would pass under section 62 in favour of the 1974 head lease, then ask whether the words of this exclusion clause are sufficiently clear to strike those words out again. By submission, they are not. It is not sufficiently clear, at least insufficiently clear, the words of the exclusion clause, whether it is intended to apply to accept subsisting rights as a whole, or only to accept subsisting rights which would not restrict future alteration, etc.
That's a different point from the pure construction point, isn't it?
It is a different point.
Subtly.
It is subtly different because of the way in which the exclusion provisions of section 62 operate. They are by the terms of the statute something of a modification of sort of general principles of construction. But they must apply in this case because, as I've said, these rights are ones which would be transmitted by section 62, and therefore you have to approach this exclusion clause through the lens of section 62(4 and the way in which that provision has been interpreted previously by the courts. That, I think, deals with the first construction point. So I'm conscious of time, I'll move on to the second construction point, which is the one raised in the respondent's notice. The meaning of the words except those now subsisting. When one looks at the judgments below, His Honour Judge Gerald's judgment at paragraph 85, and then Adam Johnson's judgment at paragraph 96, just looking at the latter behind tab 11, the judge considered the wording of this particular part of the clause was clear. He agreed with my submission that it must refer to rights which at the date of the 1974 head lease already existed as easements of law or in equity pertinent to any particular property. In my submission, that should be upheld. There is no reason to construe the word subsisting in this sense in anything other than its natural meaning as rights or liberties or advantages appertaining to or enjoyed with Duchess of Bedford House, which were already in existence in the sense that they were the subject of an existing grant or reservation or had otherwise arisen by prescription. So they subsisted in law as established easements rather than being merely liberties, privileges or advantages which would be converted into easements by the statutory magic of section 62 on the grant of the 1974 head lease. It makes perfect sense in my submission for the draftsman of the exclusion clause to provide for the transmission with the 1974 head lease of rights which already existed pertinent to Duchess of Bedford House, but to prevent the creation of new rights in favour of Duchess of Bedford House by the statutory magic of section 62 in ways which may be unpredicted or unpredictable. So the draftsman had in mind the distinction which I referred to earlier in writing McAdam, the two ways in which section 62 may operate. It's my learned friend's submission that the judges below should have construed the words except those now subsisting more restrictively as applying only to rights expressly granted under the 1938 head lease, under which Duchess of Bedford House had previously been demised. The problem with that submission is, first of all, that there is no warrant for such a restrictive interpretation. And secondly, it wouldn't in fact catch anything because the only rights expressly granted by the 1938 head lease is a right of way over Sheldrake Place East in favour of Duchess of Bedford House, which is the same right which is granted expressly by the 1974 head lease. And once again, I pray and aid the requirement for clear words. so I dealt with that very quickly, that second point. I'll move on to the third point of construction,
Thank you.
which applies in relation to the second limb
Yeah.
of the exclusion.
Which might.
As it defiles. Might. The contrasting approaches of the judges below on this particular point of construction, His Honour Judge Gerald said that for the right to be excluded on the grounds that it might restrict or prejudicially affect future development, it must be shown that the hypothetical development which the right is said to restrict is one, quotes, grounded in reality.
Just remind us which paragraph number that is.
Paragraph 87 to 89. Paragraph 89. Third line from the bottom. In my judgment, such must be grounded in reality, such that a practical and realistic approach has to be adopted. And that contrasts with the approach of Mr. Justice Johnson. Paragraphs 111 to 115 and in particular 114, he considered that the word might should be given a very broad interpretation. He said one does not need to examine in detail the practical viability of any individual example. The test is designed to be crude in that once you can say that the existence of a certain right, here the right to park, might present a problem as regards any potential future building or alteration, that is the end of the inquiry. So the difference in approach of the two judges, in my submission, is one which reflects the inherent flexibility in the meaning of the word might itself. It's obviously a word which has shades of meaning, from mere possibility on the one hand to real prospects perhaps on the other. And the question is how it should be interpreted in this particular clause. We have no assistance from prior authority on that question. But I pray and aid the same points which I previously made in construing the clause as a whole. And if I'm wrong in the overall construction of the clause, then these same points in my submissions should apply to warrant a restrictive interpretation of the expression might as it appears in the second sublim of the clause. It should be construed restrictively as meaning in my submission a real prospect rather than simply a mere possibility. And if the words are construed as Mr. Justice Johnson said they should be, in my submission they are so broad in scope, once again, as to catch any right whatsoever. It is difficult to envisage a right which might not, in theory, restrict the future alteration of the servient land. You can come up with any number of theoretical possibilities as to how any right might restrict future development in the context of utilities easements which are running under Sheldrake Place. You could say, well, in the future, then there may be a development of Sheldrake Place by the construction of an underground car park, which the existence of utilities apparatus, indeed the right to, well, certainly the existence of utilities apparatus would restrict, or may also might restrict, or might prejudicially affect. The words construed in that broad sense would, as I say, catch any right you can conceive of, and that cannot have been what was intended. And again, applying the section 62.4 lens to the construction, the ascertainment of the intention of the parties by this clause, for the same reason, in my submission, one cannot say that the word might, as it appears in the second sublim, is so clear as to have that broad interpretation which Mr. Justice Adam Johnson held it should have. So, for the same reasons, or variations of the same reasons, as applied to the construction of the clause as a whole, I say that might should be construed restricted. And that brings me on past construction to the final point in the respondent's notice, which is as to the application of the second limb of the exclusion clause.
That's in the appeal notice, is it not?
It is, yes.
Yes. Sorry, you said the respondent's notice.
Oh, so sorry.
And I was slightly...
Yes.
Thank you.
No.
The application of the second limb. Yeah.
Yes. So here the point in the appellant's notice is that the appeal judge was wrong to overturn the first instance judge's holding that the right of parking would not restrict or prejudicially affect future alteration, etc., at Sheldrake Place. So, His Honour Judge Gerald, in his judgment, again, if I can take you to that at tab 14, paragraphs 87 to 90. Those paragraphs, I identify 5 reasons why the judge considered that the right to park was not caught by the second limb of the exclusion. If I can just set those out. In paragraph 87, well, sorry, not 5 reasons, but in paragraph 87 he asked the question whether the right to park is transmitted to the head lessee might prejudicially affect future alteration. And paragraph 88, he answers that Firstly, no, because of the fact that the right of way, as it's granted over at Sheldrake Place East, would itself mean that Sheldrake Place East could not be altered or redeveloped. Then secondly, at paragraph 89, he says that the suggested schemes of development proposed by the respondents are not ones which could be realistically implemented. And then paragraph 90, he said two things. First of all, the 1973 parking scheme would not be prejudiced by rights of parking, provided that it did not materially reduce the number of spaces. And secondly, he held that the suggested potential development of the gardens within Sheldrake Place were itself not ones which could be implemented, as they would be inconsistent with the use of the garden as an open space for residents' recreation. So for all those reasons, the judge at first instance considered that the right of parking couldn't be said to be one which would restrict or might restrict or prejudicially affect future alteration. Mr. Justice Johnson, on appeal, considered that the judge was wrong in that approach, principally because the judge, he said, had wrongly restricted the meaning of the word might, and that's paragraph 114, which I've already referred to. And then at paragraph 116, the judge said specifically that in relation to the one particular scheme of development which the respondent invited suggested Adam Johnson to focus on, which was the proposed parking scheme for Sheldrake Place. The judge held that the judge below had been wrong in considering that that parking scheme would not materially reduce the number of parking spaces available to residents of Duchess of Bedford House, and therefore be one which the right of parking would or might prejudicially affect.
But this is all a bit of an aside, isn't it? He's already decided this is
yes.
overturned.
Well, it may well be, but if I can just very, very quickly, conscious of the time, explain why the judge at first instance was correct in his assessment, or at any rate, his assessment is not one which should have been interfered on appeal by the appeal judge. There's 2 points. First of all, in relation to the parking scheme itself, the first instance judge was entitled to conclude on the exiguous evidence which was before him that there was insufficient evidence that any alterations to the parking layout would materially reduce space for parking on Sheldrake Place East. But secondly, in any event, the judge was entitled to find that the proposed alterations suggested by the 1973 parking scheme and any other alteration were not ones which could have been implemented due to other rights and restrictions which affected Sheldrake Place East. On the first,
That's the right of way point.
it's the right of way point, but it's not limited to right of way, as I'll explain in a moment. I've set out in my skeleton argument the factual context surrounding the 1973 planning application, and on the basis that you read that material, I won't go through it in any detail. There was a planning application submitted in October 1973 by the then owner of the head lease of Sheldrake Place for alterations to the pavements of Sheldrake Place East for the purposes of creating a set of new diagonal parking bays in both Sheldrake Place East and Sheldrake Place West. And that is the plan which I took you to earlier in the supplemental bundle tab 4, which shows the proposed layout under the scheme. That scheme, although recommended for approval by the planning officer, was rejected by the planning committee, who considered it on the 26th of February 1974, and an appeal against that refusal was dismissed by an inspector in March 1975. The most details that we have of the scheme in the material which is before the judge below are to be found in the submissions which were made in the appeal against the initial refusal, which is in the supplemental bundle at tab 8, pages 29 following. And the details of the scheme, this submission explains why the scheme is proposed to be introduced, but then the details of the scheme are set out in the paragraph which has the number J in front of it, page 32. It covers the following proposals as detailed in the drawing, referred to: A, provision of a one-way traffic flow system covering all three sides of Sheldrake Place, provision of 40 permanent car parking bays, removal of barriers and gates, etc. Before the judge below, apart from this and a very large number of objections to the scheme, which have been made by the residents of Campden Hill Gate on the original application, and also by residents of Duchess of Bedford House on the appeal, because they were only notified of the application when it went to appeal. Apart from that, there was no evidence before the judge as to the nature and effect of the scheme and how it would impact upon parking in Sheldrake Place East. And in particular, although it was proposed on the western side of Sheldrake Place East that these new diagonal bays would be created, which would encroach onto what was then the pavement separating the roadway from the garden, there was no evidence as to how that would impact upon parking on the other side of Sheldrake Place East, on the eastern side, along the frontage to Duchess of Bedford House itself. On the basis of the material before the judge at first instance, he was entitled to conclude that, that there wasn't shown to be any material impact on the right of parking by the introduction of the scheme. But in any event, even if the judge was wrong on that, the second point which he made was that the proposed scheme could not have been implemented whether or not rights of parking had passed to the head lessee of Duchess of Bedford House under the 1974 head lease, because in any event the scheme would have interfered with other subsisting rights or restrictions which affected Sheldrake Place East. The judge, at first instance, relied in particular upon the right of way over Sheldrake Place East in favour of the head lessee under the 1974 head lease. But in addition, there are two other restrictions which would prevent the implementation of any such scheme, which were, firstly, the right of parking, which subsisted in favour of the Phillimore estate as the freehold owner of Duchess of Bedford House, as it had been reserved by the 1969 head lease. And secondly, or thirdly, the restriction in the 1969 head lease against the development of Sheldrake Place without the consent of the Phillimore estate, such consent not to be unreasonably withheld. So dealing with those three restrictions very quickly, so far as the right of way is concerned, in his judgment at paragraph 1 and 4, Mr. Justice Adam Johnson didn't consider that the right to park didn't consider that the right of way itself necessarily prevented development which a right to park would prevent. But so far as the proposed parking scheme itself was concerned, it's difficult to see how that could have been consistent with the right of way granted in favour of Duchess of Bedford House. As we've just seen, the scheme depended upon the implementation of one-way traffic around the whole of Sheldrake Place. But the rights of way in favour of the head lessee of Duchess of Bedford House were over only Sheldrake Place East. And therefore, residents of Duchess of Bedford House exercising their right of way would have been unable to drive over the whole of Sheldrake Place East following the one-way system as the scheme envisaged. So the scheme was inconsistent with the rights of way as they were granted. It may be said in addition that the rights of way as they were granted were not limited to the surface of the road itself, but also over the pavements, either side of the road, and any scheme which involved the removal of the pavement would itself amount to a substantial interference with the right of way over the pavement. on that basis alone, it's sufficient to conclude that the 1973 parking scheme could not in any event have been implemented. In addition, whether or not the right of parking was transmitted by the 1974 head lease up to the head lessee of Duchess of Bedford House, it would still have subsisted for the benefit of the freeholders, the trustees of Fenimore Estate. And the freeholders would have been free to do with that right as they wish. So they could have licensed to individual residents of Duchess of Bedford House the use of parking spaces in Sheldrake Place East, or indeed they could have chosen subsequently to pass on by way of easement those rights, even if it hadn't been passed on in 1974. So, because the...
Sorry, this is looking at the position before 1974.
This is the position after 1974, because the rights which were reserved to the trustees by the 1969 head lease, even if they weren't transmitted down the line in 1974, they were still retained by
that's the point I'd like you just to clarify, because I thought your case was that they were transmitted down the line in 1974, and once they've gone down the line, they can't stay at the head of the line as well, can they?
The point made against me is that the rights weren't transmitted down the line. So if they were
yeah, but from your perspective and your case is that they were transmitted down the line. So if they were transmitted down the line, this doesn't work after 1974. But you're saying, if I'm not right about that, and they weren't, then they were still held by the freeholder, head lessee, QED, all of this.
QED, exactly.
Okay, I'm sorry.
Yeah.
I follow.
So the subsistence of these rights in favour of the freeholder by itself would have prevented any development of Sheldrake Place. And again, that in my submission provides a complete answer to the point that the transmission of the rights may prejudice future development, because such future development would be prejudiced even if they weren't transmitted. And the final point is that the 1969 head lease, clause 2.9, contained a restriction against development. This is tab 7, page 104. So the lessee of Sheldrake Place was restricted from making any alteration or addition to the demised premises or part thereof without the previous written consent of the landlord, such consent not to be unreasonably withheld. So any mooted development of Sheldrake Place East could only have proceeded with the consent of the Fenimore Estate. In considering whether or not to give consent, the Fenimore Estate didn't have an entirely free hand, because they couldn't act unreasonably. But in reasonably, on the question whether they could reasonably withhold consent, it's Triton law that the trustees could take account of their own property interests, and that's Iqbal versus Thakra, paragraph 26. I don't think I need to take you to that. But in addition, the trustees would have been entitled to have regard to the interests of the residents of Duchess of Bedford House in deciding whether or not to grant consent to any development. They would have been entitled to have regard to the interests of the residents of Duchess of Bedford House because the covenant was a covenant against alterations, was a restrictive covenant which under section 78 of the Law of Property Act would have been the benefit would be passed on the grant of any derivative interests from the benefited land. So when the trustees, as the freehold owners of Duchess of Bedford House, grant a head lease of Duchess of Bedford House in 1974, they pass on with that the benefit of the covenant contained in the 1969 head lease restricting development. And it follows from that that because the covenant benefits the residents of Duchess of Bedford House, that the trustees, in considering whether or not to grant consent, are entitled to take account of the interests of those persons. And the authority for that proposition is the decision in Hicks versus 79 Holland Park Road. Which, final authority bundle, is at tab 30 of the bundle. Again, it's a judgment of Mr. Justice Lewison. And this concerned the question whether the owner of the freehold of a block of flats had unreasonably withheld consent for the development of adjoining land, which had been sold by that owner to a purchaser on terms which contain restrictions against development without the vendor's consent, not to be unreasonably withheld. And the question was whether the vendor had, in refusing consent, been entitled to take account of the interests of the individual flat owners within the block of which it was the freehold owner. Lord Justice Lewison held that he was, for the reasons which he set out in paragraphs 31 and 32 of his judgment. And if I can just invite you to read those two paragraphs, page 4 and 5. So that's the third reason why any development would in any event have been restricted, whether or not the right of parking has been transmitted to the head lessee of Duchess of Bedford House. So I'm conscious of the time, so I think I will draw my submissions to a close at that point, unless I can assist your ladyships and your lordship with any particular point.
Could I just ask, in relation to this last point, as I had understood it from the third ground of appeal and from your skeleton, the real point that you were driving at in relation to what Mr. Justice Adam Johnson had done was that it wasn't for him to decide, using an aerial photograph or whatever, that the number of parking bays had been would be materially affected, and therefore to draw conclusions from that.
Yes.
And it wasn't for him to do that because His Honour Judge Gerald was entitled to find, as he did, about the factual issue about the effect possibly of this scheme on the number of parking bays. Whereas you've broadened your submissions in this regard, I think, and I think they fall really now outside that ground of appeal, because I'd only understood it to relate to what was open to the second judge to do in relation to a decision in relation to the number of parking bays made by the first judge.
Yeah. With respect, I don't think that's quite right.
Okay, well, that's fine. That's why I'm asking you. I want you to put me right.
When you look at the appellant's notice, tab 1, page 17, so 18.
Yes.
The third ground of appeal wrongly interfered with the findings and evaluative judgment of His Honour Judge Gerald as trial judge on the question whether the right of parking would interfere with future alteration or development of Sheldrake Place.
And so you say that's broad, but that's not how I understood your skeleton. That's all.
Yeah, well, it is broad, because when you look at the judge's reasons set out in paragraphs 87 to 90 of the judgment of this instance, they're not limited to the specific point as to the lack of evidence relating to reduction of parking space.
I see where you're coming from. Thank you.
Thank you very much indeed, Mr. Francis. Yes, Mr. Holland.
Can I start where my learned friend started and say that this is a pure point of contractual construction? I would like to draw your attention quickly to two authorities. One, both of which you're no doubt well familiar with. One is Arnold Britain, and the judgment of Newburgers. That's it. No, Newburgers. Authorities bundle divided 27 at 325 and 333 and 334. And I would just, no doubt, this is bedtime reading for all of you cited to you, but it's paragraphs 15 and then 17 to 21. And in a way, it points out the primacy of the words that the parties have used, and the fact that commercial common sense isn't to be applied retrospectively, and the fact that it may, in certain circumstances, turn out that a party has made a bad bargain, and it's not to be rescued from that bargain retrospectively by the application of business common sense. I don't say that that's the case here, but that's where you get to. That was the facts of that case are quite stark, given the rent review provisions of, I think it was the caravans in that case. The only other passage I would draw your attention to is the one that my learned friend skipped in Wood and Capita, which is the next divider. If you look at paragraph 11, that's paragraph 28, divided 28, at page 375 of the authorities bundle, he skipped over paragraph 11. I didn't say there's anything sinister in that. But if you look at the last sentence of paragraph 11, Similarly, the court must not lose sight of the possibility that a provision may be a negotiated compromise, or the negotiators were not able to agree more precise terms. I think hereafter I'll almost be an authority-free zone. Can I then look at the contextual background to the 1974 lease? Firstly, it was a commercial agreement entered into and negotiated between two commercial entities, one of whom, the Phillimore estate, was a hugely experienced landowner. It was an owner of a large amount, still is the owner of a large amount of land in the vicinity, and as we know, is commonly, very commonly, grants leases of both flats and commercial premises to various tenants. A substantial premium was paid, £140,000, and one can assume, and I'll take you to it, that it was carefully negotiated between the parties. What's also clear, actually, is that there was originally car parking within the curtilage of Duchess of Bedford House. If you go to supplemental bundle 2, which is the leasehold's title of Duchess of Bedford House, and you go to divider 3, and if you look through the various entries, schedule of notices from paragraph 7, page 7 onwards, you will see, for example, item 8 is a lease of garage. Items 20, 21, 22 and 24 are leases of parking spaces. Item 25, a lease of parking space 32, 34, 35, 36, 40, 46, 48, and 54, 50, 60. So, as originally granted, there was parking within the curtilage of Duchess of Bedford House. What the evidence before the judge is not recorded because the judge didn't think it was relevant, was that part of the problem was that subsequently a subsequent leaseholder decided that they would effectively privatise those, sell the parking spaces off, and prevent general use. It is clear, secondly or thirdly, that there were amendments to the original draft of the 1974 lease. If you go to the core bundle, page 121, if you look at clause, I think it's 2.9 Roman numerals 2, which is about a third of the way down that page, you will see two, not the word knowingly is stroked out and initialed, not to do or permit to be done any act. And again, the same word if you go to the bottom of the page. Clause 11, 3, not knowingly the word is stroked out and initialed. So there was negotiation, as one might expect, and those words were stroked out to the benefit of the landlord, because there's what is an obligation not knowingly to do something becomes an absolute obligation. If you look at clause 2.11.1, 121, if you compare, for example, look at B, immediately above the words we just looked at, as to the lock-up garages for the garaging of private motor vehicles or the underlessees or occupiers of demise premises only for no other purpose, then compare that particular clause to the one at 105. There's a similar clause in the 1969 head lease.
At 105?
At 105, go to its clause, right, it's again about a quarter of the way down. It's the user clause, it's clause 210. It says D, as the flats of the said lock-ups as private residential flats, each one, that no machinery or engine of any kind except private motor cars shall be bought, erected or set up. And you compare that to the equivalent clause of 121. The words except private motor cars occur in 69 head lease and do And we know also that the particular clause with which we are concerned, what we've called the carve-out clause, a similar clause, and that's of course at page 118 in the 1974 copies. If you go to 199, this is the 1969 headings. And you will see that the words right at the bottom, here I get without prejudice to all easements, rights, advantages, then enjoyed by work about which are dated or are added. This is the point my learned friend has made. And the words other than Sheldrake Place aforesaid are added. And of course, we know that the clause appears differently. You can see the original boilerplate clause in a lease you got, which was granted before between the 1969 head lease and the 1974 lease. It's at the supplemental bundle, divider 11. Page 106. It's a lease which was produced in evidence by the appellants in order to obtain a second permission for a second appeal. They extracted this. This is 12 Stafford Terrace. It's a house, so it's going to be different. But simply, you can see, if you go to 103, you can see the original boilerplate. That is the unamended clause. And you will recall the evidence of Miss Gregory, which the appellants filed for Lord Justice Nugee, and I think there are 7 or 8 different types of clause, but this is the boilerplate clause. As I understand it, my learned friend in his submissions conceded that the boilerplate clause, left on its own, divided into 2 separate parts, or 2 separate, as the judges, both judges, have construed it. And as I understand it, my learned friend, his case is that the words, except those now subsisting, which were added where they were, create confusion and allow him to say it's absurd to construe it the way the judge did. That's the boilerplate clause. And again, the point I make is, I think, the one that the lady named Justice Asplin made is, well, the second point is that the Phillimore estate was well used to amending clauses. It had a standard form of lease, and it was well used to amending the clauses. Another piece of background which I write are the 3 preceding leases that we've got. We've got the 1938 lease of Duchess of Bedford House, which was the lease which was surrendered on the grant of the 1974 lease. That is at supplemental bundle divider 1, pages 4 and following. We know, because the planning permission was granted for this in 1933. We know that there's a building lease originally granted on the 26th of November 1929. That's at page 67 of the supplemental bundle. We know that the reference to the planning permission is the further supplemental document at page 32 in the further supplemental bundle. That's the council's response that my learned friend, I think, is taking to in respect to the planning application. They set out the planning history, and the council asserted that planning permission was granted in about 1933. So we know that the Duchess of Bedford House was constructed sometime in the mid to late 1930s, and this is the head lease originally granted by the Phillimore estate in 1938. We know again there's a substantial premium paid for that. There is an express right of way granted over Sheldrake Place East. That's on page 5. There's an express reservation to the landlord in respect of drains and pipes. If you look at page 5, you see right at the bottom, 4th line, the building is described as lately erected, which would fit with the construction. And it's granted right of way and nonetheless over time being authorised. The roadway, hereafter called Eastern Road, that's Sheldrake, what we now call Sheldrake Place East. And then there's accept and reserving to the lessor. First, full rights at all times to use and maintain the sewers. And secondly, full rights to use, build or alter any land or buildings now or hereafter belonging to the lessor in any manner whatsoever. Sort of right exception. It's a 99-year term. It's to be used as flats. And again, the point made is there's no, in that document, there is no express grant to the lessee of any right to run pipes or sewers over the neighbouring land, nor under Sheldrake Place East. Again, strange if they had intended that. It may be, I'm not speculating, that section 62 would apply, and if there were, in this newly constructed building, if there were pipes and utility infrastructure which ran under neighbouring land of Sheldrake Place, they would have passed under section 62. But there is no express right granted, which would be strange if in a newly constructed building there had been such rights, or had been such infrastructure. One then goes to the 1969 head lease, and again, you've read this, but I make a number of points. Firstly, it is exactly the same lessors as 1974, under the 1974. It's not even the trustees, it's the identical people have let that. It includes Sheldrake Place within the lessee. So if it goes to the document itself with some demise, you will see, and this is a clause that Learned Friend relies upon, at page 98. There is reserved onto the lessors, again, we're talking about 5 lines down, where it's accepted always reserved. 1. The free running of water, soil, gas, and electricity coming from any other buildings or land or a building or said, including sewers, drains, pipes, etc. And mentions any adjoining roadway. So that's an express reservation to the lessor of a right to run pipes under the land. And my learned friend says, by implication, you can say that that means that there must be rights under Sheldrake Place East. Well, we say there's no such implication at all. That is a boilerplate clause. And indeed, if the adjoining roadway may well be the entirety of Sheldrake Place. So there's nothing can be drawn from that. And we know it's a boilerplate clause because exactly the same clause occurs in the 1974 lease. If you go to page 116 and 117, you will see right at the bottom, except always reserving unto lessors, 1, the free running of water, soil, gas, etc. I've looked at that. I think it's exactly the same words. So the point is, you can't really draw any implication about what might be there. It's a boilerplate clause included by the Phillimore estate. There is, in the 1969 head lease, again back at page 98, there's reserved all other easements, quasi-easements and rights belonging to or enjoyed by any adjoining or neighbouring premises. There immediately beneath that, there's a clause which facilitates the right already granted, full power after easement those to enter and construct any sewer or drain. And again, over the page 99, immediately beneath the addendum, there's subject also, I've got right third, just under halfway down the page, subject also all rights, easements, or reputed or quasi-easements appertaining to or any of the adjoining or neighbouring property lessors, and then right at the bottom we get the clause underneath. That's the, and the reference there, and I'll come back to this in 74, the reference there to halfway down the page, rights, easements, or reputed or quasi-easements, and the reference at the bottom of the page there, deemed to include shall operationalise any ways of the shall place watercourses, sewers, drains, lights, buildings, those pick up the words of section 62. Certainly in the 1969 head lease, it is clear that the parties to that document were well aware of section 62 because they quote its words, and exactly the same thing is occurs more importantly in respect to the 1974 lease. Again,
Is that a convenient place, Mr. Holland, or were you just finishing off one more point?
yes, just one more. I was. The only other point I make is, by way of contextual background for this, is I've drawn your attention to the lease of 12 Stafford Place. Again, it's the same lessors, different lessees, different premises, but it contains the boilerplate clause. Yes, I'm now about to turn to the lease.
That's what I thought. Very well, thank you all very much. 2 o'clock.